section. I'm Nick Rudman, joined as always by the man with perfect hair, Andrew Mize. We are not a big sports media show. We don't have the hot takes, the big budgets, or the annoying talking heads. We make up for it by doing our research, working ridiculously hard, and being ridiculously good looking.
Yes, Nick, and because we're not backed by big sports media, we need your help, you, the viewer. And so whether you're listening to us on YouTube, Apple Podcasts, Spotify Podcasts, whatever your pleasure may be, that helps us so much. If you can just like, comment, subscribe, however you can help, just give us a little boost on whatever platform you're using. We would greatly appreciate us. Share us with your friends. If you want to look for us on Twitter, you can find us at SMI Football Show on Twitter as well as Facebook. Search on any other platform at Saturday Morning Inspection, or you can check us out on our website, smishow.com. We have a great show, Nick. Why don't you tell us a little bit about what we're going to do this special segment?
Oh, yeah, special segment. Really excited for this. We do a lot of talking on the show, giving our opinions and thoughts in the research. Well, breaking news that's happened over last week is Jon Gruden has filed a lawsuit with the NFL and Roger Goodell pertaining to the release of the emails that led to his resignation. Now, we know and we admit what we know. We admit what we don't know. And when it comes to legal stuff, we don't know anything. So we had to bring in the help. I got on the phone. I made some calls. We got some family and friends involved, and I got a hold of a good old family friend of mine, legal consultant extraordinaire, proud Ole Miss alumni, Mr. Sully Sullivan is going to be joining us for a special Q&A and interview to give us a deep look into this Gruden situation, and I'm excited. I think it's going to be a great segment.
And may I add, what a great lawyer name, Sully Sullivan. That just inspires me with confidence every time I hear it. So I can't wait to hear what he has to say. And without further ado, let's get into it.
We are excited here to bring in our big guest, our expert for this special episode segment right here. We've got legal consultant, expert in all things law, proud Ole Miss alum, Sully Sullivan. Sully, good to see you. How you doing?
It's good to see you too. I'm doing very well.
Yeah, it's been a long time. You've big friends of my dad, big friends of the family, and now we're able to get you on the show and get your opinion on something legal that's big in the world of football these days, and that is Jon Gruden. So as has been in the news recently, Gruden has, since details of his resignation a few weeks ago, has now responded to the league. He is suing the NFL and Roger Goodell in the court of law, and that's all we have Sully on right now to give us some more information on that. Sully, could you give us a quick walkthrough, legally speaking, of Gruden's case and what he's trying to do here?
Sure. Yeah. So Gruden hired an attorney to represent him in the district court in Clark County, Nevada, where he sued the NFL, unnamed defendants for future reference. That happens sometimes whenever discovery comes about and they bring other names into it. They'll add those individuals to the suit. So they do that with usually with John Doe's and Jane Doe's and John Doe's and that sort of thing, or they do Doe's and Roe's. Basically, that's where the word Roe v. Wade comes from. The lady became a plaintiff, and she remained anonymous until later on in the trial, or it might have been just after the trial. So that's pretty common in law in lawsuits to sue unknown defendants along with those who are known, because it is an organization. It's not just one individual, even though they named Goodell in the lawsuit. They also had people who were not named. That's why they do that. So what it basically is this, okay? It comes down to Jon Gruden believes he was targeted. It has affected his income present and his income future. There are several civil statutes that cover that sort of thing, including other legal concepts that are not necessarily statutes, but what is referred to as common law, right? Okay. Overall, this type of law, there are several different areas of law that people practice. There's criminal law, right? And so there's individual property law. In other words, like if you develop a book or any of those kinds of intellectual property, there's law that people practice to protect that and or to go after people who may have harmed someone in some way by, for example, using their movies to make money whenever they don't have a license to do so, things like that. This particular area of law is what is referred to as torts law. And basically what a tort is an act or omission, right? It can be either an act, a positive or a negative kind of a thing is the way they look at it. So an act or omission from one person to another person that causes harm intentionally. An example would be, well, these are examples that I'm about to tell you in this lawsuit. Essentially, there are 6 areas that Jon Gruden has sued the NFL and his commissioner over. They are intentional interference with contractual relations. I've got them here in my notes. Hang on just a second. I'll just read those to you. That's basically what the law. And by the way, the attorney that wrote this complaint and filed it with the court was very good about sectioning each of these alleged torts out so that the court could look at those, address those one at a time. Okay. It's yet to be determined whether or not this will be decided by a judge or if it will be decided by a jury. Either side can request a jury. If no side requests a jury, then the judge will be the trier of fact. That's how that works. In a torts case like this one, some people refer to them as civil cases. It's the same. They're almost interchangeable words. In a civil case like this, in Nevada, state court level, district court level, it will be 6 jurors that will decide if they do have a jury trial. So a second complaint in the filing is a tortious interference with future economic interests. So those are the first 2. Number 3 is general negligence. I can talk about negligence in a minute if you're interested. And then negligent hiring. And usually, and I did look up the statute in a couple of these because all of these 6 complaints are born of common law. Okay, so they existed before any statutes were written about them. It just so happens in Nevada, they have a statute for these. Not all states do that with all common law, but Nevada does with this particular set of laws.
Now, Sully, I, being a legal expert, obviously know what common law means. But for our viewers out there, would you mind, maybe we can just give a brief description of what you mean when you do say common law?
Okay, without giving too much of a history lesson, Britain and all the protectorates and or those of us who rebelled against that country that were formed centuries ago adopted what was already established over many centuries in England, and that is the English and British law system. We refer to it as common law because most of it was not written down. It was handed down from attorney to judge to attorney, etc. So it became common practice, for example. So here's the way it worked in England. The Crown could not hear all trials. It's just there's no way for a king or a queen to sit in court all day and hear as many trials as you would have, not to mention the fact that they had protectorates around the world that they needed to make sure they kept law and order. So they appointed judges who represented the crown. So they were referred to as a crown's court. So a crown's court that would make a decision on a point of law that had never been decided before would set a precedent, much like the Supreme Court of the United States does today whenever they interpret the Constitution. So these judges over time would coalesce these rules so that they became common. Like, for example, a common law definition of murder is the killing of one human being by another with malice aforethought. And basically what that means is a person intends to kill another person. That's murder. Well, now in the 50 states and territory and in the territories of the United States, that common law definition has been turned into a statute. And you'll hear a lot of times on television programs and in the movies, 1st-degree murder, 2nd-degree murder, 3rd-degree murder. These are refinements that America did with the common law that they adopted from English rule that best fits that particular state's goals with respect to punishing people for committing murder. Not all states have degrees of murder, so each jurisdiction is a little different when it comes to that sort of thing. That's what common law is. It's the laws that are generally agreed upon in all the jurisdictions with nuances of difference.
So like laws that have been set through past legal precedent or other cases and things like that. Is that correct?
That's correct. One could argue that, since we brought it up earlier, that Roe v. Wade is really kind of a common law, yet it was written because the Supreme Court made the decision, but it was commonly accepted and now is commonly accepted everywhere, even though you can't go and find it in statute. You can't find it codified anywhere in anybody's statute. In fact, you find laws that actually kind of go against that particular law. So,
in these tort claims, typically, in my experience, limited, are usually for damages, correct?
Yeah, when you're speaking about torts, you're looking for A, that there's been harm done, and B, that you can recover damages to right a wrong, to right your harm. There are a plethora of examples. This one here makes a good example because this is a pretty straightforward complaint. It may not be a straightforward answer as to how the outcome will be in that particular court or with that particular jury, but the complaint is straightforward. An example would be let me
Let's
tell you.
Let's go into that. Yes.
So let me tell you make sure I find them. So after I told you that number 4 was negligent hiring. Another claim that they're making is negligent supervision. Those two are found in the same statute. They're related to each other. They kind of go hand in hand. It's like you can't have, for example, generally you cannot have in criminal law a battery, which is the actual physical touching of someone, without some level of assault. In other words, assault is someone, the strictest legal definition of assault has been kind of muddied in different jurisdictions. Most people hear assault and they think someone's been hit. And yeah, in some states that is true. But from the common law definitions, assault is the apprehension that you will be hit, that you will be struck with something, right? Gun, spear, hand, rock, whatever. The battery is the actual touching, right? So those kind of go hand in hand, assault and battery. That's why you hear assault and battery quite often. Same with this. They're claiming negligent hiring, which generally includes negligent supervision to go along with it. So not necessarily, but generally.
So you talked about all these claims. Is this something that Gruden and his legal team will have to prove individually to be awarded damages, or is this something where they are all going to be aggregated and it's up to one individual trial or judge ruling or whatever to make that decision?
Yeah, that's the whole point of trials, right? So what you have is one side is complaining against another. It doesn't matter what type of law you are talking about. If it makes it inside a courtroom and it becomes a trial, then you got one side in controversy with another side, and you have a judge and jury sometimes that are the triers of fact to make the decision about which side is making the compelling argument based on the evidence available. That's how they make their decision, based on the evidence available, and who's believable sometimes comes into play, and whether or not it actually was a violation of law comes into play. And that's what the job of the two opposing side attorneys is to wade through the minutia that you might hear in the news media about any trial you want to pick off the shelf, and actually get down to the nuts and bolts of what does the law say, what does common law say, what is generally practiced in America with respect to making a decision in this area.
So it seems to me that this Gruden case has been built upon 4 separate torts or charges or accounts of things. So he's built himself up a case, I guess, to protect himself. So say they don't agree with one, he has 3 more options to fall back and possibly win his case towards. Or are they all, is the case built on he has to prove all 4, or could he get 3 of the 4?
You can get one. There's actually 6 complaint sections. Yeah, and he can get all 6 or get 1 or none.
So it seems like a smart way to do it, to give himself the most amount of chances to get some
strategy.
damages.
It's a normal strategy that attorneys use whenever they're filing a complaint against someone. That's absolutely right. That this is a strategy. That's why you see all of these. Can you argue these? Yeah, you can argue them, but some of them have less strength than others. I gave them to you in the order I think is strongest to weakest. So did the attorney who filed it. So his list is in the same order that I went and did it. I did my own analysis of it. And I'm like, yeah, this guy's, he's much more experienced in torts law. I've never done torts law, and so he knows what to do in this particular instance. And he started with his greatest chance first, and that is his claim that there was an intentional interference with a contractual relationship between him and his employer.
So when we talk about intentional interference, you brought up targeting, that, the NFL was targeting Jon Gruden. Could you go into maybe what Gruden's legal team is going to try and use to prove that there was some targeting or anything like that?
Yeah, it's pretty basic, actually. That's why I find this a fascinating suit. I really wasn't paying attention to it. I knew this had happened to Coach Gruden, but I had no idea that what his response would be. I mean, when you're not in the middle of the NFL and you're a casual watcher like some people are, or maybe you're really into the NFL like a lot of Americans are, you really don't have an insight into the inner workings of what goes on in the business itself, right? But it's like any other corporation in America that you have an HR department and you have servers that take care of emails and things like that. So why do I think this is the most compelling and probably the strongest element that he has? It's because there were 650,000 emails investigated by a team in a case that was unrelated to this particular case until they made it related to this particular case by someone leaking one email. What I'm about to say has not been presented into evidence in a court of law and proved to be fact. So this is hearsay, me reading articles, which oftentimes can be wrong because they're relying on inside information, and people will tell them some type of information, and sometimes obviously there's opinion and biases in the information that they receive, and until you get that information and actually look at what actually happened and do a forensic analysis of the email train and the email timelines, you really don't know what I'm about to say is true. But what I've read in more than one place is one email was released that was enough to damage Gruden's reputation and to get the media talking about it, which oftentimes can be a catalyst for someone being released. He wasn't released. There's an allegation there that because he wasn't released, the person who leaked the email threatened to leak more emails. Once more emails were released, then his employer recommended that he resign. That's the way they do it at those levels. He was basically fired. And so because he's the only emails that were released out of 650,000 that were protected by the NFL because they thought it would be better to leave this as an internal investigation with internal results, this particular attorney is saying to the court whenever he files this, they targeted him, even though there was an order by leadership to protect this information. The leadership failed to ensure that information was protected.
Now, I think a huge part of this is, like you brought up, the 650,000 emails that have been addressed, and only 3 or 4 of those have been released. Through the discovery process, obviously, I would assume a prudent prosecutor or defense is going to look through those emails, or their team will look through those emails. Do you think those emails will be brought into this case? And if so, is there a chance that those emails then in turn get released to the public somehow?
That's a tough one to ask. The scenario I can see is this. The judge will have to make a ruling on which emails are pertinent to the case at hand. And those may only be a certain key positions within the NFL, such as Roger Goodell, maybe some of his immediate subordinates. Not sure how their hierarchy is structured, but there may be some people that like the football operations vice president, those kinds of people will likely release those emails within a certain time frame to get an idea if there was conversations between those people and Roger Goodell. That's what the prosecution will push, is to limit it to that and not release it to the public. The defense is going to want to look at every single email that ever happened during that time frame to see if they can find out who was who was having discussions about maybe targeting Coach Gruden. So there's a legal term, without going into a foreign language with you, because a lot of this stuff is in Latin. There's a legal concept known as it rests on his face. Right?
Interesting.
And it rests on his face that he is the only person damaged by these emails, because he is the only person whose emails were released to the public. So on his face, he was targeted.
Okay.
His challenge, Coach Gruden's challenge, is going to be proving that A, the NFL did it on purpose rather than someone hacking into the accounts, and B, because that'll be what the defense says. Someone could have hacked this. There's no way to target the people you are targeting as being responsible for this particular attack. There's no doubt there was an attack. They'll concede that there was an attack. They'll concede that it hurt his future and his present economic gain, but they won't concede that their clients are the ones that released it, and that they did not do everything possible within reason, what a reasonable person would expect a company to do to protect your information. They'll bring what I would do if I were defending them. I would bring out recent examples of cybersecurity breaches in corporations that seem to be prevalent for the last 5 years with some of our best known companies in America, be it Target or any other company that had breaches in their security that go beyond just email. They went to personal information that could be damaging to someone, such as your social security number, bank account numbers, your checking account number, debit card numbers, etc. So that would be the defense's way of thwarting this allegation. So the defense is going to want to see emails especially from Roger Goodell and others in leadership positions. And so that'll be something that the judge will have to decide on. I suspect you will get something somewhere in the middle.
So when you say the defense, you're talking about the NFL's
Yep.
leadership, the NFL's legal team.
Yes. So the plaintiff is the one that complains, and the defense would be the NFL and Roger Goodell et al.
So the legal team, is this sort of a strategy for the defense, for the NFL in this case, where they're only going to try and get the emails, even though they're on the side of the NFL, they only want the information pertinent? Are they worried about leaks, or is it just a goal of managing information for their case? Why don't the legal team for the NFL already have all of these emails, with them and prepared to act on it?
I'm not sure I understand the question. What do you mean? Why aren't they?
So if let's say the NFL actually had those emails, they had 650,000 emails, and they only released a few of them. They actually are guilty of what they're being alleged to being guilty of.
I see what you're saying.
I
think it's a little bit late for them to try to say that we were going to release them all now, because the damage has been done. Now, after they've been, because there's been a suit filed. Were they to do something like that, that would have had to have been already done. Hey, we had every intention of releasing them all. This is just the first, I see what you're saying. This is the first wave. It's too late for that. They haven't made a public announcement for that, nor have they shown in their behavior that that's what their intent was. In fact, the only thing that they've really shown over the time since that investigation happened with the Washington football team was that they were not going to release these to protect some of the people who were the complainants in that particular action, in that particular internal investigation.
Now, this case is really kind of just in its infancy. There really hasn't been a whole lot of information released. There's not a game plan out there as to what either side's stance is going to be on this. But in your experience, just from the general knowledge we have about this case, I have a twofold question for you. Part one is, how strong do you believe Jon Gruden's case may be here? And number two, do you think this case is the likely outcome to be? Do you think it will go to a trial, whether in front of a judge or jury, or is this likely to get settled outside of court in your experience?
I think that Coach Gruden's, I think his goal here is to release all the emails. I think his true goal is to see if he can get the emails released to the public, so that we can open up and see what else, what other, and this will be kind of what I think he's thinking, what other dirty secrets they can find that have nothing to do with Jon Gruden and could embarrass the NFL like the NFL has embarrassed him purposely. I think that's what his real goal is.
So no money really is what he's looking for. He just wants to get even, so to speak.
Yeah, I think exactly what it is. He doesn't need the money necessarily, although he is losing quite a bit. I really do think this is a poke in the commissioner's eye, and to tell him, hey, you don't get to push people around. I'm going to push back. And I think that's what this really is about, is for him to get these emails released.
So how would that happen? What would have to happen for those emails to get released publicly?
It would have to happen during discovery, and winning the case, I think, would help him. That's something that they will fight. They will vigorously fight to keep that from happening. So that's why I said, what's my prediction? My prediction is that maybe they'll be released, but it'll be I think it'll be released to the defense and not to the public, is what I think a judge might. That's where he might go. Of course, it's all speculation until they start finding out more facts. I need more facts to have a better opinion.
Very interesting. Nick, do you have any last questions?
Go ahead.
Well, I guess for me, one of the big things that's kind of curious about this whole thing is you talk about Gruden doesn't really need the money. It's more poking the eye in the NFL. It's almost kind of a weird deal in my mind, where Gruden's reputation is hurt, but obviously suing the NFL, his reputation is now zero, right? Before maybe he had some chance to go back and coach. Now he has none. Obviously, no one's going to hire him, at least not in the NFL.
Approach.
Does that kind of influence? I'm thinking, I kind of agree with you that Gruden's out for a pound of flesh. He's coming full speed ahead, trying to do some damage to the NFL. Do you think this is going to be a long-term thing, trying to get through, even if it doesn't work out well for Gruden? Is he going to go through maybe some sort of appeals process and just fight this out forever, and the NFL is going to fight forever? Is this going to be a multi-year kind of process here?
Hard to tell. I mean, it likely could be multi-year before it ever gets to have to even go to an appeal. It could take a year or two, maybe longer, just to get the decision from the original filing, right? I mean, they've got to get on the docket. There has to be discovery. There have to be depositions of witnesses, etc. I wouldn't be surprised if you find later on that Coach Gruden already knew who to target in the NFL with respect to finding out what conspiracy may or may not have happened to target him, which was, by the way, the sixth element of this particular lawsuit, which is civil conspiracy.
And
very
we
similar.
all know who that is.
Yeah, we do, maybe. So civil conspiracy is one of the allegations, and it is very similar to criminal conspiracy for people who know what that is. The only difference is it's not a crime; it's a tort that has happened. A crime from one person to another, but not criminal in nature. More civil in nature. There's nothing civil about it, but you know what I mean.
Yeah. So one other question, this is kind of getting out maybe a little bit more in the weeds. I don't know. So the NFL, at least in my mind, is kind of a weird organization because it's made up of the 32 franchises. It's
right.
Like a franchise management company is kind of how I kind of think about it a little bit.
Mm-hmm.
How does that affect this case? Because if these emails are related to maybe what a franchise did, there's the investigation of Washington. Will that prevent Gruden or his team for getting access to any of that information just because maybe it's not really the NFL's to own, it's Washington's or another franchise?
So the NFL, I believe, and this is from reading. I don't have factual information on this one, but I believe the NFL now has a copy of all the emails because they're the ones that were the broker of trying to run a fair investigation of the internal workings of the Washington football team. I mean, it's one of those things where how do you have the people who are being accused of committing infractions investigate themselves? It's better to have a broker do that. That's the whole reason that the NFL and the commissioner in the NFL exists. All the owners need someone who represents them, to the business world, to go out and let contracts for what type of soft drinks they're going to buy and all those kinds of things and what venues they're going to use, et cetera. Negotiating with local cities like Las Vegas and others for maybe upgrading a stadium. That all falls to the NFL and the commissioner and the people that work there on behalf of all of the owners of the NFL. So they are a leadership group who are beholden to the owners, but at the same time have the power because of the other owners when someone steps out of line to put them back in line. So they have the control that they need to control the emails, but of course they're also on the servers of the Washington football team. I presume that the servers are at each team. Perhaps there's a central server that that they use, that everybody from the different franchises plugs into, much like a corporation. Which brings up an interesting point that you make, and that is that the team there in Nevada is a franchise, just like all the other teams are. Which this is one of those things that maybe I can reach out to you later and give you the answer to this one. But one of the things I thought about during this segment is another legal concept known as diversity of citizenship. A diversity of citizenship means that one citizen of one state cannot sue another citizen of another state in his home state. It has to go to a federal court, or it can go to a federal court unless you waive it as the person from the out from the other state. And what that does is it makes sure that someone who's being accused from another state in your state isn't unduly prosecuted by locals. That's federal law. It's constitutional law. That was set up in the Constitution whenever it was formed and ratified. I don't think it's going to be an issue in this one because you have the franchise there, right? But because the franchise is there, the way it works is if there's a corporation that does business in your state, even if their headquarters is somewhere else, they're considered to be a citizen of that state because they do business in that state. But it is a question that would be, I would at least ask other attorneys, if I had one here present at the House, I would ask them, hey, is this one of those diversity of citizenship defenses that the NFL could use to move this to federal court? My answer is 90% no, but it's still an interesting legal point to ask, because is a franchise really the NFL, or is it the franchise? Do you work, for example, do you work for the Raiders, like Mr. Gruden, or do you work for the NFL? It is a question that I would put before the judge, even though I kind of already know what his answer is going to be. It at least puts it out there, right?
What do you think the answer is going to be? That's something I thought.
They'll stay in Nevada.
Yeah, I think it's Gruden works for the Raiders, and the coaches. The coaches and everyone else. The only people who I think could maybe be classified as working for the NFL is an owner, or maybe a player.
Yeah, I don't know. So it brings up an interesting legal question that will be probably settled by a judge. It may already be settled law. It's one of those I haven't looked up. I just kind of thought about it as we were sitting here, knowing that the NFL is not headquartered there, and that and Nick, you brought up that these are franchises where they have representation by the commissioner and his staff. Yeah, so I wonder, is that really an NFL site? My answer is going to be 90%. Yeah, it is.
It's all very interesting. So just to kind of sum it up for my little pea-brain mind here to capture this, the NFL was acting as an investigator, got some information from the investigation, and Gruden is alleging that the NFL or some actor in the NFL released information to that investigation that interfered with a contract Gruden had with the Raiders.
That's it in a nutshell. And everything else he's alleging grows out of that.
All right.
You absolutely have it nailed. That's correct.
Okay. Very good.
Really quite interesting. Nick, do you have any last minute points before we don't want to take up too much of Sully's time?
No, I think I'm good. I think I heard enough 4-syllable words for the next 3 months. So.
I'm really going to have to go home and take a minute to digest all of this information. It's actually quite interesting and quite informative. Sully, we can't thank you enough for joining us. We really appreciate it. This is something that we thought would be a very interesting thing to do, and you've provided some valuable insight for us and our listeners. So again, I can't thank you enough. Nick can't thank you enough for coming to join us.
You're welcome. No problem.
And maybe we'll touch back in with you later, see if we can, once there's a little more meat on the bone, we'll see what else it comes into play into this.
Sure thing. Let me know.
All right. Well, we will see everybody next time.